Alright people, so welcome to Jumbo IS and welcome to our current affairs lecture series in which we will cover a particular day's current affairs within 30 minutes. Now today we are going to cover current affairs from 19th of August. So all the important news items that featured in today's newspapers shall be covered in today's lecture. Now needless to say this, make this lecture series a part of your daily routine because only then you'll be able to get a hold over current affairs, okay? And current affairs forms the most important portion of your UPSC preparation. So I need not lay out the importance of this particular subject, right? So make it a part of your daily routine. It would only require 30 minutes of your time. All right then, enough of the introduction. Let's straight away dive into today's lecture. But first, let's take a look at the list of topics that we shall cover today. So let's begin. So daily current affairs, 19th of August, and here are the topics. The topics are not that plenty, but still, they're important ones. Number one is 75th anniversary of IITs. 18th August marks the 75th anniversary of the first IIT that was created, that is IIT Kharagpur. So we'll talk about this news item. It is very important because government has laid out a new vision for IITs, how we are going to use IITs for India's development. And topic number two is with respect to AI training in India. Which kind of data can be used by AI models for training? Okay, this is very important because currently there is a case in Delhi High Court. This and the last news item would be Apex Court upholds hanging for execution. Apex Court over here means Supreme Court, and Supreme Court basically is hearing a case. Basically, it heard the case, it gave its judgment. Someone filed a petition that should you use hanging for death penalty or should we use some more caring, lenient ways of giving someone a death sentence. So Supreme Court upheld that hanging is the perfect way of giving someone death penalty. So what is this entire matter? What constitutional articles would be discussed in this? We'll discuss this as well. Okay, so these are the three news items that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number one, and that is 75th anniversary of IITs. Now, it was in 1951, 18th August 1951, that, well, India decided to create its first IIT. That was IIT Kharagpur. And that was created, the building that was used to create this IIT was a former prison used by the British government. Okay, so it's fascinating. Basically, India wanted to make a statement that that same building that was used to incarcerate Indians, to punish Indians, will be used to make India proud, to develop India, modernize India, right? So this is the irony in that whole situation. Yet, after IIT Kharagpur, many more IITs were created, and we all know that IITs in India are the best technological institutions. Okay, some of the IITs are best in the world also. I mean, in some branches. So IITs are our pride. We all know about it. But the thing is that government has recently realized that, well, there are numerous engineering colleges in India. Yet, people value IITs. So we can't have this system. We can't have this dual system that IITs give very good in education and all the other colleges produce substandard engineers, right? So now IIT is currently at the top of the pyramid, right? But now we will use IITs to strengthen the pyramid itself. So IIT faculty members, IIT laboratories will be used to help tier 2, tier 3 engineering colleges. Plus, if India wants to become Vikasit Bharat by 2047, we need to reform IITs as well. Because the new world, new technologies require new kind of curriculum for the students, new kind of approach for research also, right? So what is this vision for IITs 2047? We need to discuss this at this momentous occasion of 75th anniversary, right? So let's discuss this entire matter. Okay, so 75th anniversary of IITs, here's the context. August 18, 1951, okay? It was basically established at a colonial incarceration, that means prison site. Now remember, IITs have been given the status of institutes of national importance. Okay, this is a tag given by Indian government to important institutions, and government takes care of them, right? As India approaches the centenary of its independence, 2047, the benchmark of institutional excellence must evolve. We need new approach to manage IITs. Not simply how high an IIT rises, but how much of Bharat rises with it. So our focus won't be to make IITs top-notch. It would also be that how we use those IITs to make other tier 2, tier 3 colleges top-notch. You understand the approach, right? Now, as far as the historical evolution of IITs is concerned, well, here's a brief timeline. So the Sarkar committee, which was created, pre-independence committee, they said that we need an institute in India on the same lines as Massachusetts Institute of Technology in USA. So basically, IITs have taken their inspiration from MIT, the best tech institution in the world. Okay, recommended regional higher technical institutions modeled on MIT. Then we founded IIT Kharagpur, established at Hijli Detention Camp, Tech for Sovereign Nation Building. Okay, so its job was to provide technology, train technologists for nation building. Again, make India, modernize India. Then Institute of National Importance tag, IIT Act 1965, codified autonomy. Okay, so they were made autonomous institutions. Okay, the professors, the management committee was given some autonomy, non-interference from the government. Research mandate, they will take on path-breaking research, and governance system was also automated. That is why IITs stand apart as compared to other colleges. Now, government is thinking about this fourth point. Shift from isolated top institution. IITs are considered islands in India. They are top institutions, but they are isolated. We need to integrate them with other colleges as well to national capability platforms. Platforms, IITs will be used as platforms from where all colleges, all research institutions would take benefit from. Okay, this is the idea. So what are the core features of this IIT framework, 2047 IIT framework? A university without intellectual walls. You see, the thing is that within IITs, there are different departments. So there is a physics department, mathematics department, civil engineering department. All these departments function independently. But modern problems, today's problems, require collaborative approach between physics, mathematics, AI, computation, right? Currently, the research needs to be interdisciplinary. You can't make them isolated departments. There should be a mechanism where all these departments can collaborate on various research projects. Basically, these watertight walls separating these departments need to be made more porous. This needs to be done for interdisciplinary research. Interdisciplinary research is important. Sometimes to solve an issue, you require environmental science, mathematics, physics all together. So this is there. Then, a national research and innovation engine, functioning as high technology foundry linking basic laboratory research to commercial spin-offs via research parks and living laboratories. IITs need to share their research infrastructure with private companies also, because the research done at IITs can benefit various commercial startups. So we need these partnerships. So IITs shouldn't house its own labs. It needs to create research parks where all can do research together, including private startups. This needs to be done. Then teacher and knowledge multiplier. This is very important. Serving as a capability platform that mentors state university faculty and shares laboratory infrastructure across institutional tiers. What this means is that for many teachers at different engineering colleges, these IIT professors can act as mentors. So these teachers at different engineering colleges would get the much needed experience, which would be shared with them by IIT professors, and that would improve the level of education at these tier 2, tier 3 colleges as well. So IIT professors would mentor other colleges faculty as well. And a public institution accountable to society. So aligning research, all the research work should align with India's national goals. Okay, like energy transition from fossil fuels to non-renewable, renewable, public healthcare, agriculture, sustainable manufacturing, research in these areas which are priority number 1 for India. This needs to be done. So the 5 pillars of reforms for Vision 2047 IIT are as following: 5 strategic pillars. From apex of the pyramid, currently IITs are at the top of the pyramid. It needs to strengthen the entire pyramid. Remember the mentorship, sharing of research labs and all, that needs to be done. Breaking silos, breaking these departmental walls, interdisciplinary research. Okay. Then admission diversification. This is very important. All the students that get into IITs have to give this exam JEE, right? That shouldn't be the only criteria for admissions. Okay, we need multiple criteria. Students, best performing students from science olympiads can also be chosen. Various workshops, various internships are there. Best performing students can be given admission to IIT. So it shouldn't be just JEE. Other areas of recruitment or admissions should also be made open. Okay, JEE is not a final verdict. Clear? And that would stop paper leak also. You see, these high prestigious exams are more susceptible to leakages. So we need multiple modes of entry for students. Then redefining the degree, change the curriculum for current needs. IIT curriculum is still outdated as compared to other top institutes, MIT and all. Do that. And currently all the tests, the exams have been made AI proof. The focus is how students are basically prevented from using AI in their exams, right? There is a plagiarism check, AI check in their assignments. Well, we need to stop that. We have to recreate these exams to enable usage of AI, because students are after all going to use AI in their real life. So change your tests as per AI so that AI will be used. Still, you are going to test the capability of a student, right? Don't make it AI proof, make it AI enabling. The test should be redesigned in which students can use AI. Like there are certain exams in which you can use a calculator as well, right? That needs to be done. So here is a tabular table way comparison between the earlier approach to manage IITs and the new paradigm shift. Okay, we have discussed all the points, but they are given in a summarized form in this table. This table is also shared in your notes, so do check this out from your notes. Okay, and well, the way forward is very simple. Whatever was discussed in the vision document. Okay, operationalize the teacher multiplier mandate. What is teacher multiplier? That IIT professors shall act as mentors to other colleges' teachers. Then expanding open access digital infrastructure, lab infrastructure should be shared. Research parks should be created. Reorienting R&D towards strategic national missions. Research projects in IITs should be oriented towards India's national priorities. And institutionalizing alternative admission pilots. Not just JEE, other modes of admissions should also be opened up. Okay, you need to diversify this because talent can come from anywhere. Right? Make sense? Okay. That would be all as far as the first topic is concerned. And now let's quickly shift our focus to next news item, and that is AI training in India. You know, all these AI companies are creating these powerful AI models, ChatGPT, 5.6, 5.1, Gemini. All these are creating these powerful AI models. Now, these powerful AI models need data for training them, right? So what currently what they're doing is, well, all these powerful AI companies are using books, using internet data, and they are using newspaper data, digital news data to train their AI models, right? Now, well, various news agencies have objected to that. They say that whatever articles they publish are copyrighted. They have a copyright. That means they have the exclusive right to produce, reproduce, and earn money from it. Their commercial interests are basically attached to their quality of editorials. If someone uses their editorials and publishes them in their newspapers, well, that would be theft. That is protected under copyright. Now, these AI companies, what they're doing is they're using these editorials, these articles, train their AI models, and now people, for any information, people don't have to go to that newspaper's website. They can just ask a question on ChatGPT, and ChatGPT using those articles would give an answer, right? So these news agencies are saying it is a violation of our copyright. They are saying that, but AI companies are saying that it is not. Now, already there is a case going on in American courts. Okay, it's called OpenAI versus New York Times. So New York Times is a news agency, right? They have filed a lawsuit against OpenAI and even Microsoft. A similar case has been filed against OpenAI by ANI, the news agency in India, in the Delhi High Court. So currently, Delhi High Court is listening to arguments presented by ANI and other news agencies and OpenAI, the AI company. Yes, that is currently going on. Now, the thing is, maybe these AI companies would lose that case in American courts, but they might win this case in Indian courts. Okay, in India, they might win, AI companies I'm talking about, but in America, they might lose. And that is because the copyright law in America and in India differs. Okay, now how does it differ? We have to investigate that. We need to know about our intellectual property rights, right? Especially copyright. So let's talk about this, okay? So AI training in India. So this is the current problem. Delhi High Court is adjudicating a landmark lawsuit by news agencies like ANI against OpenAI, examining whether data scraping using data to train large language models on copyrighted texts, news articles, creative works without explicit licensing constitutes copyright infringement. You know, if you want to use the news articles published by ANI for commercial use, remember, if your company wants to use ANI articles for commercial purposes, okay, then you have to take a license from ANI and you have to pay ANI for it. That's the copyright law. But if you are doing it without taking a license, then that is a violation. AI companies are doing it without a license. So it is a violation as per ANI. Now, Delhi High Court is listening this case because OpenAI also has some arguments in its favor. We'll talk about that. The legal dispute brings India into the global intellectual property debate because currently a parallel case is going on, New York Times versus OpenAI and Microsoft, testing the boundaries of India's statutory fair dealing exceptions under Section 52 of Copyright Act. Okay. Now here's the thing. In India, you can use news articles given by ANI without a license, but only in certain circumstances, not all circumstances, certain circumstances, certain cases. And that is listed down under Section 52 as exemptions, exceptions, okay, called, well, fair dealing. Make sense? So you don't have to take license for every occasion. There are certain occasions where you are exempted from taking a license. Those are listed down in fair dealing. In America, it's called fair use. In India, it's called fair dealing. So what's the difference between the two? Okay. Now here's the dispute. Okay. How does LLM or these chat GPTs use news data? So AI developers scrape vast public data, including news. They take it. Then they train their models. Text are converted into numerical vectors, basically the science to train data models. Then once they are trained, now you ask any question and they will generate an output. LLM generates summaries. They give different opinions for or against those articles, everything. Okay. Now currently this legal challenge is going on, infringement of Copyright Act. They are saying that what LLMs are doing is not part of fair dealing. LLMs are saying it is part of fair dealing. Okay, this is the thing. So let's take a look at the arguments presented by both sides. Okay, so the arguments given by the complainant, basically the news organizations. They are saying that under Section 14 of India's copyright law, it is their exclusive right to produce, reproduce, use, store their creative works. Okay, it is their exclusive right under Section 14 of Indian copyright law. And do all of this for commercial purposes. If anyone else wants to do it, they have to take a license. It's given in Section 14. So they have cited this. Then, well, they say that AI is prone to errors. Sometimes AI gives the wrong answer. Okay. Now, most of the times AI can do this if they are hallucinating, basically giving errors. That they will use an article given by ANI. They will cite ANI as the source and then give a completely wrong answer. That would basically lead to loss of credibility for ANI. Because when you read the answer, you saw ANI source as, at the bottom. So this is there, okay? Their answers are prone to hallucination, errors. And the most important thing why these news agencies are, well, they filed this petition is because of market substitution. Now people don't need to buy any subscription from ANI or print or The Wire or NDTV. They don't need any subscription. If they want to know anything, they just have to type a prompt on ChatGPT and they will get the summary of these articles. So people would stop taking subscriptions to these news agencies. That would lead to a significant commercial loss to these news agencies. This is their biggest problem. Clear? So they have cited Section 14. But AI companies also have some defense. And what is their defense? Well, look, you see, you cannot store copyrighted material with yourself also. Under Indian copyright law, you cannot store copyrighted material with yourself for commercial interest. So AI companies are saying that we don't store your articles the way they are. Okay? Well, we train our data models on different, there is a science behind it. We are not reading your articles. We are just telling our AI models to associate different words with each other, assign weights to them, give prediction analysis, all these things. So it is not basically like a third person taking your article and printing it in their own newspaper. That's not there. Then, transformative technological utility. Well, it has a lot of utility because we don't just reproduce your articles. Okay, we inform public about various things. We use these articles to give our opinions, conservative opinion, left-wing opinion. We do all sorts of things. We do analysis, all sorts of things. So we are using public information to produce new material. We are not exactly copy pasting your material. We are giving our own analysis. Okay, and with this, information accessibility with public would increase. So this is permissible. In fact, under Indian copyright law, if you are using public facts from any news article, that is not punishable. Okay, but if you are exactly, you just, I mean, under Indian copyright law, journalistic expression, their creative way of writing articles, that is protected. Public facts are not protected. They say we are only using public facts and rewriting them in our own way. That is permissible. So now we need to compare between Indian copyright exemptions, American copyright exemptions. So in India, it's called fair dealing. In USA, it's called fair use. And listen to me very carefully. In India, there is an exhaustive list what you can do with copyrighted material. Okay, so the exemption list is exhaustive and we stick to that only. It's not open-ended. So what can you do without taking a license? If you're using that material for private use, research, your private usage only. If you are criticizing a journalist or news article or reviewing their reportage, okay, reporting of current events, if only public facts are being used, citing news articles, that is permissible. Okay, but if you are copy pasting that article and producing it in your own newspaper, news website, that is not allowed. In America, there is no exhaustive list. In fact, American courts look at this issue on a case-to-case basis. They don't have an exhaustive list. In fact, the courts of America have created a fourfold test to check whether this should be exempted or this shouldn't be exempted. What is that fourfold test? They first see what is the purpose of using someone's copyrighted material. Is it commercial, not for profit, what? Then, what is the nature of copyrighted work? Have you exactly copy pasted or you have given your own opinion on that news article? Then, whatever you are doing, is it causing any harm to the commercial interests of that newspaper? That is taken into account. This is fourth, whatever I just explained. And third point is how much data you have stolen. I mean, the quantity of data that you have taken also matters. All these four things are looked at and then an opinion is given. There is no exhaustive list, right? Now, there is a proper tabular comparison between Indian copyright law, which is fair dealing, and USA, fair usage. Whatever we have discussed is given over here. Okay, it's given in your notes also. So you need to remember two things about Indian copyright law. Okay, first, Indian courts have said that the overall idea of the journalist, okay, that would be protected. But public facts can be reused by anyone. There is a strict separation between public knowledge and the creative way of writing that article. Creative way is protected, this is not protected. And yes, you cannot store someone's copyrighted material. But, well, under section 52, you can temporarily store it. AI companies are only temporarily storing your data to train their models. So under Indian law, well, the thing is they are protected because India exempts copyright infringement under its own law, and this dichotomy is given more importance. In USA also takes a look at whether you are causing significant harm to commercial interest of that news agency. If it was USA, ANI, NDTV, Aaj Tak would have won. But it's India. In India, we don't protect public facts. So in India, OpenAI might win. This is the thing. Okay. Now, why is this important for India? Why is this Delhi High Court judgment important for India? Number one, The thing is, if we favor news agencies, it would be a problem. Why? Because Indian AI companies do not have that much money to take licenses from these news agencies. Whereas OpenAI, if it loses, then eventually it will take a license from ANI, New NDTV and all, because they have more money. So OpenAI would win and Indian AI companies would lose. And this is a big jolt to India AI mission. Then this is there. So if news agencies win, this is a problem. So we need to balance it out. But we also need to make sure that news making is not a loss-making business. We need to protect them as well. So we need to take a balanced approach. Plus, this is on the rise. So we need to encourage this. Before taking their data, OpenAI should have a bilateral agreement with ANI. Okay, the quantity of data they'll use, what they'll do with it. This should be encouraged. This is the balanced approach. Already this is happening. So this is the thing basically, right? And now let's quickly conclude this topic and now move on to next news item, and that is Apex Court upholds hanging for execution. So in the Honorable Supreme Court, someone filed a petition and they said that yes, death penalty is legal in India, though there should be a debate on it. But the method to give someone death penalty should be changed. Okay, in America, they don't hang you. They basically give you a lethal injection and then you die. It is a painless death, more humane form of death. Hanging is more cruel. So someone filed a petition that we need to give up hanging and go for lethal injections because this is more humane, that is more cruel. And they have said that using humane forms of death penalty is allowed under Article 21. Article 21, right to life with dignity, also includes right to die with dignity. And right to die with dignity is also available to prisoners also. So in that regard, we need to change our death penalty mechanism. So this was argued in the Honorable Court and the Supreme Court gave its judgment. Supreme Court said that, well, you might say hanging is cruel. I understand. But I don't think lethal injections are better because there is a huge failure rate that has been reported in USA. Okay. And because there is no other better alternative, more humane alternative than hanging, therefore we are going to stick with hanging. But in future, if you can find a new way, less cruel way, then we can go for it. But as of now, hanging stays. This was the case. So let's take a look at this. Though I've explained this matter entirely to you. Okay. So let's take a look. So Apex Court upholds hanging for execution. So this is the case. It's a 2-judge bench. They have dismissed this PIL. Okay. The PIL was based on right to die with dignity, which is part of Article 21. Now, here's the thing. Death penalty, also known as capital punishment, you need to know about it. Okay, you need to know about its historical roots. So hanging as a way of giving capital punishment was started during British times. Okay, so the British enacted this law called Criminal Procedure Code, CRPC. Okay, so it was part of section 368 of CRPC 1861, to be hanged till death. This was included in it, right? 35th Law Commission 1967, they also said that hanging is much superior way because there is no other alternative available. So even Law Commission agreed to it. Then there was this landmark ruling called the Deen Dayal versus Union of India. Deen Dayal, this person was also called Deena. 1983, 3-judge bench upheld hanging under Article 21. They said that any methodology for capital punishment should pass this 3-fold test. So this Supreme Court bench gave this 3-fold test and hanging passed this 3-fold test. If you'll find another alternative which performs better on this 3-fold test, then we'll go for that. But currently hanging stays. Then CRPC was replaced by Bharatiya Nagrik Suraksha Sanhita in 2023 and this provision was retained in that. Now the Supreme Court has reaffirmed hanging in this latest judgment, reaffirmed the Deena judgment, Deen Dayal versus Union of India, right? So just remember this. Though let me tell you that in India, as per BNSS, hanging is the only way you can give death penalty. But under Army Act, okay, Army Act, Navy Act, Air Force Act, well, these military courts can punish their military personnel. Okay, they also can punish them for court martial. And they can also give death penalty, by the way. For them, there is an exception. They can give death penalty either by hanging, and they can also give death penalty by firing by squad. A firing squad would fire at you and you would die. So it is allowed for military courts only. For civilians, hanging is the only option available. This is one thing I just wanted to communicate. Just remember this. For traitor, someone betrayed India during a war, well, death penalty can be given by military courts. It can be via hanging or firing by a squad. But for civilians, it's only hanging. Just remember this, okay? Now, so what is the petitioner arguing? The one who said that please remove hanging. Well, dignity at gallows. In Gyan Kaur versus State of Punjab or Common Cause versus Union of India, the Supreme Court said that right to die with dignity is also available to prisoners. So he said that it should be available to convicts. Okay. Then he said that India uses a form of long drop method for hanging. Okay. What do we do? When you hang someone, they don't die of lack of breathing. What happens is you drop them. Okay. You have seen hanging in movies. So you drop them. It's called long drop. So because you drop so quickly, and once you reach the bottom, there is a jerk. That jerk separates your vertebrae with your spinal cord. So your brain and spinal cord connection gets broken, and then you die very quickly. So it's a quick death. Okay. But he says that many a time there have been evidence that this break doesn't happen and the person dies of, well, asphyxiation, which is more cruel. Sometimes this method doesn't work. There have been errors. So it is cruel. And he said go for lethal injections, which is being used in some states of America. This is more clinically proven and better, painless death. So this is his argument. But the Supreme Court said, well, we only look for this threefold test in Dina case. What was that threefold test? The methodology must be quick and simple. Hanging is quick and simple. Must cause the least amount of physical and mental pain. Well, if the long drop is quick, the death is also quick. It must avoid barbarity, torture, and degradation. And they say, because there is no other alternative method which performs better than hanging on this threefold test, we are going to stick with hanging. You say lethal injections are better, but well, we have heard a lot of news reports where lethal injections have failed and they have caused painful deaths. So we don't go for lethal injections. Plus, you haven't provided any evidence that lethal injections are better or any other form is better. In future, if you'll give that evidence, we'll go for that. But for now, hanging stays. Okay? This is the thing. For now, hanging stays. Now, in your notes, I've given this table, different forms of death penalty, like hanging, which is used in India, Japan, Singapore, lethal injection by USA, China, firing squad by Indian military and some US states also, and electrocution, electric shock. Well, in the olden days, some US states used to do that. So their benefits, their risks, failure rate, all of that is given in this table. Do check this out. Okay. And yes, some landmark judgments with respect to death penalty. Okay, this is important. Landmark judgments, just remember them. These landmark judgments are important for prelims. Okay, so someone challenged death penalty because some European states have banned death penalty. They allow life imprisonment but not death penalty. So in 1980, someone challenged death penalty that India should also remove capital punishment. Supreme Court did not remove it. Bachchan Singh versus State of Punjab, Supreme Court said that death penalty should be used in rarest of the rare case, but it should be used. Okay. Then we have talked about this Deen Dayal versus Union of India case. And then Shatrughan Chauhan versus Union of India held that inordinate, yes, this is very important. Well, if someone is given death penalty, but the date of their death is delayed inordinately, okay, so without any reasonable explanation, if you delay their death sentence, then that person is eligible for commuting their death sentence to life imprisonment. Eligibility is there. This was there. Okay, you cannot, because if you delay their death sentence, the person is living in constant fear that I'm going to die, and they live their life in that fear. Be quick. So that person is eligible for life imprisonment. So these are the three important judgments that you need to be aware of with respect to death penalty, right? And that would be all. So with that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. I'm sure about it. What you have to do is do these two things. Number one, be consistent and regular with this lecture series. And number two, revise the lecture from the notes provided by us. That is very important if you want to retain these current affairs at least till your exams. So do that, and I shall take your leave with the promise of some other news items in the next lecture. So thank you so much, everyone.